I'm going to open the hearing on Assembly Bill 424, which revises provisions relating to parole. When you're ready, Chair.
Good morning, Madam Vice Chair, members of the Assembly Judiciary Committee. My name is Steve Yeager. I represent Assembly District 9, which is located in Southwest Las Vegas. And this morning I present Assembly Bill 424 for your consideration. I was hoping to have Assemblyman Hambrick joining us from Las Vegas to testify in support of the bill. Unfortunately, he had some medical issues this morning that prevented him from appearing in Las Vegas. But as you are all aware, and as we've said before, Assemblyman Hambrick has been instrumental in the legislature for advocating for young people who end up in our criminal justice system. And I'll get to why Assemblyman Hambrick is important to this bill in just a moment. But I do have at the table with me in Las Vegas Christina Wildevelt, who you have heard from in this committee on other bills. And I know there are other folks in Las Vegas who would like to testify in support and help present the bill. In addition, we have Mr. James Dold on the phone with us this morning. You might remember Mr. Dold testified in front of this committee earlier in this session on two of Assemblyman Hambrick's bills, both of which we passed out of committee. So Assemblyman Hambrick, Mr. Dold, and Ms. Wildevelt were among those who were instrumental in helping to pass Assembly Bill 267 of the 2015 session. That obviously is not the bill that you have in front of you today, but the bill in front of you today, Assembly Bill 424, builds upon some of the progress that was made in Assembly Bill 267 of the 2015 session. Before I tell you about that bill, let me tell you that it passed the legislature by a tally of 63 votes in favor, 0 against. And I also had the honor of working on that bill, though as a lobbyist, not a legislator. And I was very happy to see Governor Sandoval enact Assembly Bill 267 of the 2015 session. So what did that bill do? That bill did something critically important. It provided hope. It provided hope to individuals who had committed very serious crimes as juveniles and received life sentences or the equivalent of life sentences. These were individuals who were functionally sentenced to die in prison for things they did when they were not yet adults in the eyes of the law. Assembly Bill 267 of the 2015 session provided that anybody sentenced as a juvenile for a crime that did not result in a death was eligible for parole after 15 years. It also provided that anyone sentenced as a juvenile for a crime that actually resulted in a death would be eligible for parole after 20 years. Again, parole would not be mandatory, but those persons would be eligible for parole. Assembly Bill 267 of the 2015 session, however, did not provide that same opportunity to anybody convicted of a crime where more than one death resulted. This has resulted in odd outcomes, where in some cases, one co-defendant who pleaded guilty to one murder has been released, but another co-defendant in the same case involved in the same acts will never be released under the exclusion that's in the current law because that offender pleaded guilty or was found guilty of multiple deaths rather than one. Ms. Wildevelt will tell you a little bit more about that and about one particular case where that situation is occurring right now. So the bill in front of you, Assembly Bill 424, makes anybody sentenced as a juvenile eligible for parole at 20 years, even if there was more than one death. Again, we are talking about eligibility, not mandatory release. The parole board would still go through its normal process, assessing risk and hearing input from victims and victims' family members. The bottom line is there was no logical basis to include the 2 or more deaths exclusion in the original legislation. As you will hear from Mr. Dold, juvenile offenders are unique in their ability to be rehabilitated. Mr. Dold will discuss some of the brain science and legal opinions in this regard. To be clear, the individuals this bill would apply to committed egregious crimes. But keep in mind they were committed as juveniles, and this bill gives them a chance at parole. It doesn't guarantee it. That would be entirely in the discretion of the parole board. Hope is a powerful thing, and we have the power to give hope with Assembly Bill 424. I anticipate that you might want to know how many imprisoned people in Nevada Assembly Bill 424 would apply to. It's hard to know for sure, but our best estimate is somewhere around 8 people. 8 people who are imprisoned in our state who continue to be excluded under the 2 or more death exclusion in the law. 8 people who are now adults. They're still in prison and will spend the rest of their lives there for crimes committed as a juvenile. That's 8 individuals with no hope of ever getting out of prison. It's time to do the right thing and give those remaining 8 or so hope. Madam Vice Chair, with your permission, I would like to turn it over to Mr. Dold, who's on the phone, to make some additional remarks, and then to Ms. Wildeveld in Las Vegas before we open it up for questions.
Is available on the phone now. Would you like him to? Okay. Mr. Dold, can you hear me?
Yes, I can, Madam Chair.
Okay, please go ahead.
Great. Thank you so much, members of the Assembly Judiciary Committee, for the opportunity to testify remotely. I apologize that I could not be there in person. I actually had a prior commitment out in Hawaii, and that's actually where I'm calling in from this morning. Let me just first start off by thanking Chairman Yeager for introducing this really important human rights bill on behalf of children in Nevada. And I also just want to send my thoughts and prayers out to Assemblyman Hambrick. As all of you know, and has been mentioned earlier, he has been one of the strongest champions for children's rights in the state and really sort of all around the country. We are praying for him, and our best wishes go out to him. So I thought that I might start off my presentation this morning by giving a little bit of background about this issue and why this issue is back before the Assembly Judiciary Committee. And as we go forward, there are 2 ways that I think committee members can look at this issue. There's sort of the moral lens, which I think the chairman has sort of laid out. And then there is also the legal lens, which I think plays a significant factor into why AB 267 was drafted the way that it was and why this reform is needed at this time to make sure that Nevada is in full compliance with the U.S. Supreme Court decisions in this area. So a little bit of background about how we got to this place. So back in the late 1980s and early 1990s, there was a juvenile crime wave that had happened. And there was a group of criminologists that had theorized at that time that there was a new group of super predator children who were coming of age who were more violent and less remorseful than ever before. These children were characterized as being godless, jobless, and fatherless. And state legislatures across the country were urged to pass laws making it easier to transfer children into the adult criminal justice system. At the same time that was happening, we also saw a spike in the increase of mandatory minimum sentencing, truth in sentencing laws, and of course the 94 Omnibus Crime Control Bill, which also encouraged states to pass harsher sentences and to build more prisons to house these individuals. During that time, however, there was really no focus on child status or how children are fundamentally different from adult offenders and how we need to be looking at them differently. So we fast forward about 15 years from that time frame to 2005, and the U.S. Supreme Court begins to weigh in on the constitutionality of the use of the most extreme and abhorrent sentences imposed upon child offenders. So in 2005, in a case called Roper v. Simmons, the U.S. Supreme Court took up the issue of whether or not children could be sentenced to death. And at that time, the court was relying heavily on emerging juvenile brain and behavioral development science that Ms. Wildeveld alluded to, which showed that there were fundamental differences between juvenile and adult brains. Specifically, the prefrontal cortex is not fully developed in children, and as a result, children rely on a more primitive part of their brain known as the amygdala, which results in children being more impetuous, being more prone to risk-taking, being more susceptible to peer pressure, and less likely to think through the long-term consequences of their decision-making. Their underdeveloped brains is also one of the reasons why children, their personalities aren't as well fixed, which means that they are more amenable to rehabilitation and change over time than adult offenders necessarily are. And so in this, the court remarked at the time that this was something that every parent or grandparent knows, but really for the first time, science was being able to show us in real time. Now, our policies already kind of reflected this reality. It's one of the reasons why we don't let children vote. They can't serve in the military. They can't enter into contracts. There's legislation this session pending in Nevada to make sure that children under the age of 18 can't get married, for example. And all of these policies sort of reflect the reality that children, their brains aren't fully developed. They're not capable of making the best decisions, and they make irrational decisions sometimes. And this is also exacerbated by children who grow up in horrific crime-producing settings. It's no surprise, it should come to no surprise, that a lot of the children that we see in these sorts of scenarios are kids who have experienced severe early childhood trauma and have great exposure to adverse childhood experiences, which sort of connects all of these issues together, really. So in the studies that have been done about this population, one of the things that becomes apparent is that over 80% of the girls, for example, who've been sentenced to life without parole were victims of childhood sexual abuse. Close to 40% of boys were also victims of sexual abuse. Over 50% of children witness domestic violence and violence in their communities on a regular and ongoing basis. Now, that's not to excuse the underlying criminal behavior, but it does help us to understand how children could end up in these situations where they commit these terrible crimes, because in addition to their undeveloped brains, they are also dealing with these horrific crime-producing settings oftentimes in which they grow up. And so against that backdrop, the U.S. Supreme Court found that the penological justifications for imposing the harshest possible punishment, in this instance in Roper, the death penalty, fall away when we consider a child's status. And as a result of that, the U.S. Supreme Court struck down the use of the death penalty in 2005, saying it violated the Eighth Amendment's prohibition on cruel and unusual punishment. 5 years later, in a case called Graham v. Florida, the court again stepped into this area, saying that the use of other extreme sentences, like life without parole for non-homicide offenses, also violated the Eighth Amendment's prohibition on cruel and unusual punishment. In that case, the court likened juvenile life without parole to the death penalty, because no matter how much a child changes, and no matter how much they grow and show that they are a different person today, no matter how much remorse they express, they'll never leave prison alive. Essentially, they'll only leave prison in a pine box. And so for that, the court said that that is a sentence that simply cannot be imposed on children convicted of non-homicide crimes. 2 years later, in Miller v. Alabama, the court again struck down the use of mandatory life without parole for children, even those convicted of homicide-related offenses. Again, the court explained that the lack of maturity and an underdeveloped sense of responsibility and children being more vulnerable to negative influences and outside pressures lessen the reasons for imposing the harshest possible punishment of life without parole. And in the Miller decision specifically, the court noted that, before a child could be sentenced to life without parole, that a judge had to consider the differences between juveniles and adults, including the child's background and other mitigating factors that caution against imposing a life without parole sentence. So as the Miller decision came down, it sort of sent shockwaves really across the country, and people really began to think about why we impose these harsh sentences on children in the first place. And there became a big question about the scope of Miller's application. So after Miller came down, a number of states with what we call discretionary life without parole sentence, and Nevada being among those states, began to re-examine whether or not that was an appropriate sentence, and even if it was legal in light of the Miller decision. And so and a number of states had decided that it wasn't, including South Carolina and Ohio, and we saw other states pass laws in this area like West Virginia that didn't have mandatory life without parole. And so against the backdrop and understanding why AB 267 was constructed the way that it was in large part at that time, there was a recognition that the state needed to do something that these decisions very well may impact them, may impact the state, and that would mean that there would be costly litigation that would happen as a result, because there would be a need to go through and resentence all of the individuals who were impacted by that decision. And so as we were developing the language around AB 267, we tried to focus on developing a compromise that sort of took into account the Miller decision, as well as some of the concerns that were raised at that time. Now, after AB 267 was passed in 2015, the following year, the Supreme Court issued another decision, this time in a case called Montgomery v. Louisiana. Now, this decision fundamentally altered our understanding of the Miller decision, its application, and its scope. And I think it's against that backdrop that we have to look at why AB 424 is a really important piece of legislation that needs to be passed as a technical amendment and fix to AB 267 to make sure that Nevada is in full compliance with the U.S. Supreme Court's decisions in this area. So in Montgomery v. Louisiana, the issue that the court was deciding was whether or not the Miller v. Alabama decision was meant to be applied retroactively. Now, what was unique about Montgomery was that the court actually went pretty broad in its sort of pronouncements of what Miller meant and what Montgomery meant. And so specifically, the court, I'm going to read a couple of lines from this decision because I think it's really important for the context of this conversation. Here, Justice Kennedy, who wrote the decision, said, Miller determined that sentencing a child to life without parole an unconstitutional penalty for a class of defendants because of their status. Even if a court considers a child's age before sentencing him or her to a lifetime in prison, that sentence still violates the Eighth Amendment for a child whose crime reflects unfortunate yet transient immaturity. Miller did bar life without parole for all but the rarest of juvenile offenders, those whose crimes reflect permanent incorrigibility. Miller's conclusion that the sentence of life without parole is disproportionate for the vast majority of juvenile offenders raises a grave risk that many are being held in violation of the Constitution. So what Montgomery ultimately did here was clarify that the Miller decision was very similar to the Roper and Graham decisions that came before it, in that it did completely bar life without parole sentences for children, and it made one carve-out exception. If a state can prove that a child is beyond rehabilitation or is permanently incorrigible, then that's an instance where a state could theoretically impose a life without parole sentence. Of course, the complication comes in, how does one make that determination? And I would submit that it is not possible to actually determine whether or not a child is permanently incorrigible, because we never know who a child may grow into. Indeed, when we look around the country at some of the state Supreme Court decisions that have come down in the years since Montgomery came down, a lot of the courts have actually cited to this fact that even trained psychologists and clinicians cannot make a determination on whether or not a child is permanently incorrigible or could be rehabilitated over time. So the Iowa Supreme Court, for example, most recently the Washington State Supreme Court struck down the use of life without parole sentences completely for child offenders because such a determination under the Eighth Amendment simply cannot be made. Now, what the U.S. Supreme Court did in Montgomery is it gave states a way to comply with this decision in a way where they wouldn't have to go through a process of resentencing. And here I'm going to read again from Justice Kennedy's opinion. He says, allowing those offenders to be considered for parole ensures that juveniles whose crime reflected only transient immaturity and who have since matured will not be forced to serve a disproportionate sentence in violation of the Eighth Amendment. Those prisoners who have shown an inability to reform will continue to serve life sentences. The opportunity for release will be afforded to those who demonstrate the truth of Miller's central intuition, that children who commit even heinous crimes are capable of change. In the years since Montgomery has come down, a number of states have also continued to pass laws in this area, which have removed these exclusions that currently exist within AB 267 to make sure that every child, including those convicted of multiple homicide offenses, have the opportunity to see the parole board. So today, 26 states and the District of Columbia completely ban or no longer use life without parole sentences. And these are sentences that really run the geographic and political gamut. These are states like West Virginia. Matter of fact, West Virginia was the first state in the country to completely give children, no matter what their offenses, parole eligibility after no more than 15 years. Similarly, Arkansas, which is certainly not a progressive bastion by any stretch, also gives children the opportunity to see the parole board, regardless of the number of victims in the case as well. And again, sort of looking at this through a compliance mechanism, but also through the moral lens that a life without parole sentence is vastly disproportionate for a child offender. Now, that is not to say that every child who commits a serious crime should be released from prison. Now, I will be the first to tell you that there are some individuals who commit serious crimes who should never be released, who will stay in prison for the rest of their life. That is a determination that only the parole board can make after a child's brain has had the opportunity to mature, and we have a long record to look at to see what they've done since they've been incarcerated. And I'm very proud of Nevada, and I think everyone should be as well, on how the state, particularly under the leadership of the former parole board chair, Connie Bisbee, had gone about implementing AB 267. Numerous individuals have gotten a second chance to come home. One individual, actually, he was 15 years old at the time of his crime. He is now married. He's expecting his first child. These are really sort of life-altering laws. And I think what Chairman Yeager is trying to do with AB 424 is to make sure that the same rationale that applied to AB 267 is applied to all kids, no matter what offense they commit, because no child should ever be denied hope or love. And that's what we do when we sentence children to life without parole, is we deny them the opportunity of hope and love. And that's why AB 424 is really important. It's not to say that everybody should get out of prison, but we should at least offer them the opportunity to demonstrate to us that they are a changed person and are deserving of a second chance. That's more sort of the moral aspect of this, and the legal aspect is, we don't want to have to go back into court and relitigate the 4 cases of individuals who are serving life without parole sentence currently in Nevada, in addition to the other 4 individuals who are serving what we would term de facto life sentences. And I would just close out my testimony as in urging the committee to pass this bill by also citing to the scripture. When we look at the Bible, it's replete with examples of individuals who were fallen and did some very terrible things, but yet went on to serve God in very significant and important ways. Moses, David, and the Apostle Paul were all guilty of murder. And I think it's really important to remember and ask ourselves, as we debate these really important pieces of legislation, that if our children are not deserving of our mercy, then who amongst us is? And with that, I'll be happy to close my testimony, answer any questions from the committee, and would just urge the committee to act favorably upon this legislation as a technical amendment fix to AB 267. Thank you.
Thank you, Mr. Dole. Chair, would you like to start questions? Or okay, I have a question from Assemblywoman Krasner.
Thank you. Thank you for the presentation. My question is for Ms. Wildeveld, please. You said that there's only a handful of these cases in Nevada that resulted in multiple deaths. Can you please tell me what type of cases, what the charges were? Thank you.
Thank you, Assemblywoman Krasner, through the Vice Chair. This is Christina Wildeveld. All of the cases that are life without the possibility of parole or de facto life sentences have been murder. The disparity between the sentences is significant, as I indicated with Colby Becker, who was 15 years old, along with Kyle Ray, who was also 15 years old. The victims were all Kyle Ray's family. Colby pled to 1 murder. Kyle Ray pled to 2 murders. Kyle Ray will never get out of prison. Colby Becker was released a couple of weeks ago and is married and living a life here in Nevada that is beyond expectation. Kenshawn Maxey was also a double homicide. One of the victims would have been a co-defendant, but for the bullet going through the bartender and hitting the co-defendant behind him and killing them both. The third co-defendant was Artis Moore. Artis Moore is getting relief under AB 267. Kenshawn Maxey will never get relief. And then the other cases, Tim Webb, who we had referred to, he is a supporter here today that will be testifying after me, was also a double homicide. The driver of that vehicle, who was an adult, was found not guilty. The Tim Webb was serving 30 years in prison, and the third co-defendant was released after a short amount of time. I hope that answers your question. And then I can give you synopsises on the other individuals, but I'll leave it to you.
Thank you.
Mr. Edwards?
Thank you, Madam Vice Chair. My question is, I think, pretty simple. This bill would make Nevada law consistent with 3 U.S. Supreme Court cases, correct?
Steve Yeager, for the record, that is correct. One of the things we're trying to do is prevent litigation, because I think the case that came out after the 2015 session pretty well, if not says expressly, at least suggests that the exclusion that exists in the law for 2 murders would be unconstitutional.
Okay, so, and even though they'd be eligible, if they are in fact some of the incorrigible ones who have not demonstrated any kind of growth or rehabilitation, they would still be left in jail.
Steve Yeager, you are correct. What this bill does is it allows someone to come before the parole board, but there is no mandatory release at any point in the process. And typically what the parole board would do is if they reject someone, that person would be typically rolled at least a couple of years, if not longer, before coming before the parole board again. And just as a matter of note, after Assembly Bill 267 went into effect, as you might imagine, I get a lot of letters from inmates, and some of those letters come from inmates who have been released, who are saying they're thankful for the opportunity, but many of them come from folks who did not get released by the parole board, essentially asking for help in being released. And of course, my response to that is, that's the process, and you'll have to continue to go before the board for as long as it takes, and you may never get out. But the bill, neither 267 nor this bill in front of you makes release mandatory for anybody.
Great, thank you.
Assemblywoman Toles?
Thank you, Madam Vice Chair, and thank you, Chair Yeager, for bringing this forward. I actually toured the Northern Nevada Correctional Facility a couple years back and had an impromptu focus group with some of the inmates there and met one of the individuals that would be positively impacted by this bill if it passes. And so I'm generally in favor of it. I just wanted to ask one question. Do we have any examples of, and of course this can't be unilaterally applied, but where individuals were released and then went on to commit more murders since we've passed this perhaps in other states?
Steve Yeager, for the record, there certainly have not been any in Nevada. I can't speak to other states. I'm not sure if Mr. Dold or Ms. Wildevelt know of any, so I would defer to them if they know the experience in other states. But in Nevada, we have not had any recidivism from those who have been released.
And Mr. Chairman, James Dole for the record. Assemblywoman Toles, I'm happy to weigh in on that. What's really amazing, I think, about all of these reforms and the U.S. Supreme Court decisions from across the country is the fact that we have a 0% recidivism rate, and there have been more than 500 individuals released across the country safely back into the community. They're doing incredible things, including one of the things that they feel a great responsibility for is giving back, because they know that no matter what they do, they can never make up for the life that they took. And so one of the things that we see them do is actually go back in to some of these horrific crime-producing settings where they came from and actually talk to young people and to go into juvenile detention facilities. In fact, last summer, just as an anecdotal example, I spent last summer touring 3 prisons in the state of Arkansas, and I had a chance to go back in with a former juvenile lifer there, Laura Berry, and we met with a number of kids, there's about 15 or 20 that were being housed in an adult facility, and we had a chance to just talk with them about their potential for change, and to express to them that we loved them and that we cared about them, and that they were more than where they were and they could be more. And so there's this positive example of hope that I think that these formerly incarcerated youth are giving to other youth who are in the system or at-risk youth across the country. And so they've been incredible citizens giving back and trying to make amends for the terrible crimes that they've committed. And like I said, one of the most incredible things about all of this is that none of them, to my knowledge, have recidivated, and we've had hundreds and hundreds and hundreds of individuals released across the country.
Thank you so much for that that information, and I know that he left a particular impression on me, and made a great case for why this is important.
Do we have any other questions? Okay, seeing none, we will move to support. Anyone in support in Las Vegas or in Carson City, please come fill in the chairs.
Just two more to go. Let's go next to Assembly Bill 424.
Assembly Bill 424 revises provisions relating to parole, sponsored by this committee and heard in committee on April 8th. This bill provides a prisoner who was sentenced as an adult for certain offenses that were committed when he or she was less than 18 years of age is eligible for parole after 20 years, if the offense or offenses for which the prisoner was convicted resulted in the death of one or more victims. There are no amendments to this measure.
Thank you, Ms. Thornton. Any questions on Assembly Bill 424 as detailed in the work session? Okay, don't see questions. At this time, I would take a motion to do pass Assembly Bill 424. Motion from Assemblyman Watts. Do I have a second? Assemblywoman Torres. Any discussion on the motion? Assemblywoman Krasner.
Thank you, Chairman. I still have some concerns with Assembly Bill 424. I do understand that the intent is trying to help juveniles. However, I am aware that Nevada currently does not have mandatory life sentences without parole for juveniles or adults. Judges still have that discretion, so I'll be a no and reserve my right to change prior to floor. Thank you.
Thank you, Assemblywoman Krasner. And just so the record is clear, you are correct that right now a judge could not give a sentence of life without parole. However, there are individuals who are serving time in our prisons now who were sentenced to life without parole at the time they were sentenced. There's not a lot of them, I think about 8 or 9, but I wanted to make that clear for the record that going forward it's not an option, but there are people that were sentenced that way, which was lawful at the time. So, additional questions? I think we took a motion, right? Okay, we took a motion. So seeing no further discussion, all those in favor of the motion, please signify by saying aye. Aye. Any opposed, nay? Okay, we have a nay from Assemblywoman Krasner. Were there any other nays? Okay, I don't see any, so that motion does carry. I'll take the floor statement, and just in case he's watching, I wanted to say congratulations to Assemblyman Hambrick as well. We're thinking about you, and we hope you're doing well, and you'll be able to join us back up here in Carson City very soon.